Okay. Good afternoon or good evening, everyone. We are starting our webinar series, but part of our financial education on wills and estates. We're going to give everybody just a little small chance to come in. We'll start it officially at 6:02. So we're just going to give everybody just a couple minutes to come on in here, and we certainly do appreciate the ones that came on in at 6 o'clock, so we're just going to start it in 2 minutes. Thank you. Good evening. Good evening to you, Miss Silva. Thank you for joining us today. Hey, Miss Ross, I see you. Good evening. Hey, Destiny. Good evening, everyone. Oh, I probably should. Miss Callie, look at you. Just emailed you earlier today. I see you. Thank you for joining us. Thank you all. Okay. All right, Miss Callie. All right, let's see what time we got here. 6:01. We're going to give everybody one more minute. We thank you for joining us this evening for this very, very important topic. Um, we're going to give them one more minute to come on in here. Okay, Maritza at 6:02. Thank you, everyone, for coming in. My name is Monica Cunningham. I'm one of the HUD certified housing counselors at Dallas Area Habitat, and I have my technical expert with me, Miss Maritza, and of course, she's handling the computer part, so y'all know she's good at that portion, and I'm just going to be the talker. Uh, we have here this evening Miss Kristen Salas. She is a licensed attorney, has been a licensed attorney in the state of Texas since 2002. She's been with the she's a Dallas volunteer attorney, and she's been there for 17 years. So she is our subject matter expert for this evening. And of course, we all need to listen to this topic because we all need this wonderful, wonderful information she's going to provide us with. So, Kristen, take it away.
All right. Thank you so much. Well, thanks for joining in this evening. As Monica said, my name is Kristen Salas. I am a mentor attorney at the Dallas Volunteer Attorney Program. And for those of you that are not familiar with what that is, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar. And what we do is help low-income Dallas residents with their civil legal cases. And we will basically match folks that qualify for our services with a private attorney that will work on their case pro bono, which means for free if they qualify. And one of the very common types of cases that we get in are folks that need help with their wills, powers of attorney, and estate planning. So that is what we are going to talk about today. So, congratulations on becoming a new homeowner. As you've gone through this series, you've learned about all the financial responsibilities of being a homeowner. And one of the things that you do need to take into account is the responsibility to handle what's going to happen to your house when you pass away and or if you become incapacitated. So having a will and your powers of attorney in place is certainly a gift to give to your family members to make it a lot more easier for them and really a service to your community to make sure that your house does not become neglected. Um, so we're going to kind of go through these various things. The basic documents we're going to talk about today are a simple will, a statutory durable power of attorney, a medical power of attorney, and a directive to physicians. So the one of the most important things is having a will. Um, so we do a lot of things at our office, and we do a lot of probate work. Probate being The process of having to transfer title to house or property when somebody has passed away. Two ways. It's very easy if there's a will, but we get a lot of folks that come through and that don't have a will. So it's very common for somebody to have owned a house and passed away, never did a will, and then their children inherit it through intestacy and say they have multiple children, but none of those children have the wherewithal to keep up with the property taxes. They don't have the money to get it probated or things like that. And usually one person will be living in the house and then maybe that person passes away and it goes down to a third generation. And eventually nobody can keep up with the property taxes and the house ends up being abandoned. And once it becomes abandoned, then you've got folks unhoused may move in. It may become a drug house because nobody's watching that house, that sort of thing. Or maybe there's a family member that's living in there, but they can't get it in their name. They can't qualify for repair through the city of Dallas because it's not 100% in their name. And they have to live in less than ideal conditions because they can't get it repaired. So all of that could be avoided by having a will in place that will specify who you want your house and your other property to go to at the time of death. If you do not have a will, basically the state of Texas has a will for you, and it's called the laws of intestacy. So it basically outlines how your property passes if you don't have a will. And a lot of people think that, well, I'm married, everything I have is going to go to my spouse. That's not necessarily the case. Back in the days when, well, I don't know the generation I'm talking to right now, but I'm going to age myself. When I was growing up, I used to watch Leave It to Beaver reruns. They was a popular 60s show. It had a mom and a dad and two kids. The mom and dad were married to each other. The kids were born during the marriage. And this is kind of your traditional nuclear family. In that particular situation, if the dad had died, um, under the laws of the state of Texas, because the children were born during the marriage, everything would pass to mom, as we often think it would. When mom dies, it would pass equally to the two kids. Contrast with that to what I call the Brady Bunch family. And again, I'm aging myself. If you don't know what the Brady Bunch are, it was a sitcom from the 70s in which a man who already had three children marries a woman with golden hair and had three girls of her own. Commonly, this is a blended family. And of course, we see this more and more in our modern culture. Um, Under the laws of intestacy, in that situation, if dad died, mother doesn't necessarily get 100%. Because they had children from other partners, what ends up happening under the laws of the state of Texas is the mom gets just a portion of the house, and the dad's children, those three boys, get the other portion. And if they don't get along, then that can cause problems. And the husband may have wanted his wife to get 100% and all six of those kids. So having a will is definitely important. So it will outline who you want to take your property in the event you pass away. And you don't have to give it 100% to your spouse. You don't have to give it to your children. You may have a child that um, has left, hasn't been involved, um, and you don't particularly want that child to have your house, and that is okay. So the will outline basically how you want your property to pass. And in the will, you will need to name what's called an executor. The executor is the person that is charged with taking the will to the probate court, getting it approved by the judge, and then the judge issues what's called letters testamentary to that executor. The executor with those letters testamentary then has the power to pay down any debts that are owed at the time of death, and then basically collect all the assets, the house, the bank accounts, whatever it is, and divide those according to the terms of the will. Now, some of you may be thinking, well, wait a second, you just said that if I have a will, I may not have to go through probate. Yes and no. So if you have a will, yes, it does have to go through probate, but it is so much simpler and easier than not having a will. Um, on average, somebody that does have a will, they can get the will approved by a judge usually in about 60 to 90 days, give or take, to be able to do the work they need to do to close the estate. If there's not a will, it gets extremely expensive, and on average, it'll take somebody, oh, a good year to get court approval to close down the estate of that person. So that's the importance of having a will. And as you're thinking about how you want your property to pass, have some contingencies built in. So, for example, I want my 100% of my property to go to my husband when I pass. I don't have any children, but if he died before I did, I would want it to go to my nieces and nephews. Um, and then I need to think through, well, what if there's a huge family tragedy and, the plane goes down and my nieces and nephews and my husband die before I do? What would I want then? Would I want my property to go to my nieces and nephews' children? Or would I want it to go to maybe a best friend? Or would I want it to go to a charity at that point? Um, so things to think about because we never know what on earth is going to happen before we die. So always kind of build some contingencies in there. Same thing with executors. We've kind of picked out the person that we want to be managing our estate, but do always have a backup um, in place just in case one, that person can't do it, or they're unable, um, or they pass away before um, you do. Um, so folks always do ask, well, I want to leave all my property to my kids. I've got my kids are great. I love them both. I want them to be co-executors and work on this together. Legally, you can have co-executors, but it's not really that great of an idea because if they don't agree on, say, for example, the sale price of the house, then they have to go back to court to get a judge to settle a dispute, which is the purpose of having a will, to avoid having to take disputes to court. When I was drafting my mother-in-law's will, she wanted co-executors. She wanted my husband and his sister to be co-executors because they would get along, they'd work perfectly together. And as I was trying to explain to her how this is a very bad idea, there was a commotion going on in the kitchen, and those two 40-something-year-olds were fighting over how to split the last cookie. And if you're like every family, your kids are probably going to have disagreements. And if they couldn't figure out how to split that last cookie, they certainly weren't going to agree on how to split the or how to agree to the sale price of the house or which realtor to use or whatnot. So luckily, my mother-in-law made the right decision. She chose just one, and that worked out fine. Um, when you're choosing the executor, you're probably going to want to pick the child that may be the one that's helping you out the most, or maybe has the most business sense of your kids. Sometimes I know in my family, my husband has a lot more business sense than his sister. His sister is great with medical stuff, but just not business savvy. So in that situation, you're probably better off with somebody it has a bit better business sense or is just there taking care of you more. If your kids are equal and they've got equal abilities, I've kind of recommended folks, just name folks in birth order so nobody gets their feelings hurt. In order to be valid, the will has to be signed before two witnesses who are called disinterested witnesses, meaning they do not take under the will. They're not your direct descendants or your spouse, and also in front of a notary. Again, the notary cannot be a witness to the will, he or she cannot be a beneficiary under the will, and they cannot be your direct descendant. You could have your cousin be the notary. That's totally fine because that's not a direct descendant, but just not your direct descendants. Um, Usually the witnesses are family friends, neighbors, that sort of thing. They have to watch you as the testator sign the will, and you have to watch them also sign the will as the witnesses, and then the notary notarizes all three of your signatures. Um, Once you've got the will drafted, you do need to keep it in a safe place. Um, where the executor could find the original. Usually that is if you have a fireproof lockbox at the house or a fireproof safe, that's the best place. A file cabinet, totally fine. We had a client that kept hers in the freezer because it was fireproof, just right next to the ice cream there. A lot of people ask about using a safe deposit box. Um, you can do that. However, I am not a huge fan of safe deposit boxes because if you pass away, the bank is not going to let your beneficiary access to your safe deposit box without a court order, which does complicate things. So it's best that you have it close at hand available with you. Okay, the next document we're going to talk about is called the statutory durable power of attorney, also commonly called the financial power of attorney. And this allows you to name somebody you trust to make financial decisions for you in the event you're unable to do so for yourself, or you could choose to have it immediately. So in my particular case, I have given my husband a statutory power of attorney that's effective immediately, which means he can go down and manage my bank account, manage my property right now, even though I am completely capable of doing it myself. Um, it makes it a whole lot easier for him to, if I don't have time to do something, then he can certainly do that for me. Or if I suddenly became incapacitated due to a coma or Alzheimer's or whatever, he doesn't have to take any extra steps in order to act on my behalf. You can also make the statutory durable power of attorney effective upon your incapacity, meaning you're in a coma, you're have dementia, whatever the case is. But in that situation, before a bank or other financial institution can act on it, they would need a letter from your doctor saying, yes, this person is incapacitated. So sometimes that make a little harder for the agent to act on that. But the agent on a durable power of attorney is what's called a fiduciary, meaning they have an obligation to manage your money for your benefit. They cannot go into your bank account, clean your bank account, and then run off to Vegas and gamble your money away. Um, that would be illegal for them to do. Has that ever happened? Yes. And that's why it's very important to name somebody you trust to do it. If that agent violated their fiduciary duty to you, then basically you could sue them to try to recover the money, that sort of thing. But again, it's very important to name somebody you trust. And the reason it's important to have this document is, down the road, if you did become disabled and you needed to sell your house in order to pay for a nursing home or nursing care or what have you, or you needed somebody to be able to get into your bank account to pay you down your bills, to pay your mortgage payments. If you don't have that statutory durable in place and the agent cannot reach your bank account, then they have to petition the court for what's called a guardianship of the estate in order to manage your property for you. A guardianship of the estate is actually very expensive for the person that is becoming the guardian, and it's also very time consuming. Basically, the person has to post a bond equal to the value of the property they're trying to manage, and they have to basically file an accounting every year of what they've been doing with that money with the courts. So, oftentimes, that's just because of the bond aspect, that's just prohibiting certain people from being able to take care of their parents if they don't have financial wherewithal to do it themselves and their parents didn't have a durable power of attorney to let them act on their behalf. So that's the big purpose of that document. The next document that we're going to talk about is the medical power of attorney with a HIPAA release. And basically, much like the statutory power, this allows you to name somebody you trust to make medical decisions for you in the event you could not do so for yourself. Um, as long as your doctor can communicate with you, your doctor will do whatever it is that you want done. But if you cannot communicate with your doctor and you don't have a medical power, then the doctor has certain people that he's going to look to make those decisions for you. And you may not want those people making those decisions. So the first person the doctor is going to look for is the spouse. And the spouse can make whatever medical decisions. If you've been separated for a long time, you may not want your spouse making those decisions. If there's not a spouse, the next person the doctor is going to look to are the children to make decisions. Well, if you've got two children and they want different things from mom or dad, the doctor's not going to know who to listen to. If you have no children or your children are minors, the next person the doctor is going to look to are your parents. Um, you may not want your parents making medical decisions. If there's no spouse, there's no kids, there's no parents. Next, the doctor is going to look for siblings to make those decisions. You may not want your siblings to make those decisions. I certainly don't want my siblings making my medical decisions. So that's why it's important to have a medical power of attorney in place that names the specific person that you want to make medical decisions for you in the event you could not do so for yourself. And it's always good to have a backup of that. The HIPAA release allows the person that you've named as the medical power to also be able to access your medical records in order to make medical decisions for you. The next document we're going to talk about is called the Directive to Physicians. It's commonly called the Living Will. And this allows you to tell your doctor whether or not you want life support in the event you are in a terminal or a vegetative condition and could not survive without it. If you have a directive to physician, this takes that decision out of the hands of your family and out of the hands of your medical power of attorney. So if you've got a directive that says, I want to die as peacefully as possible, I don't want life support, and then your medical power of attorney says, wait, No, I don't want mom passing, put her on life support, do everything you can do to save her. Um, if she's terminal past the point of saving, the doctor is actually going to do what is listed on that directive to physicians, regardless of what the medical power of attorney says. So I always recommend to folks that when you've done the directive, you've done the medical power of attorney, give a copy of that to your primary care physician so they've got it on their records and know who to talk to if in the events you could not communicate with them. We there are other documents that we do. One that you definitely need to be aware of as homeowners is called the transfer on death deed. This document allows you to name a beneficiary to your house, and your house, if you do this deed and the deed is filed in the deed records before you pass away, instead of going through having to go through your will, your house automatically transfers at your death to the person named as a beneficiary in this deed. This makes it super easy for your heirs and beneficiaries to not have to go through the probate. Um, and then likewise, you can also do a beneficiary designation of a motor vehicle. The Department of Motor Vehicles has a form that you can fill out and file with them that says who you want to have your car um, in the events that you pass away. And again, once you pass, all they have to do is show the death certificate and the car title passes immediately to that beneficiary named in the designation. Um, a lot of people have bank accounts that have a payable on death beneficiary named. That's great. If you have anything with a payable on death, such as bank accounts, life insurance, your 401k, that will pass to the person named as beneficiary in that contract, regardless of what your will says. So people do use transfer on deaths, designation of motor vehicles, payable on death beneficiaries as a way to avoid having probate. If you do that successfully, you can get away with that. But it's still a good idea to have a will on top of having these other documents in place because, again, you never know what you're going to own at the date of your death. You could have all this payable on death beneficiaries laid out, but this has happened from time to time in our office. We've gotten a refund check from, say, a property insurance made out to the person that passed away. Well, there's no payable on death on that. And it was just that check that passed under the will. So, again, good idea to have that will in place. You can also do what's called a declaration of guardian. Um, Even though you've got your statutory durable power of attorney, your medical power of attorney in place, there may be, and the whole purpose of those is to avoid the need for a guardian. There may be a situation that a guardian has to be appointed. You can name who you want to have that role in the event that you uh, passed away, or not passed away, but become incapacitated. And you can name people that you certainly do not want to be your guardian over you. And then the last document that our office does is called the Declaration for Disposition of Remains. And this names who you want to make your funeral arrangements or your disposing of your body once you pass away. So this person can consent to cremation, using whatever funeral home they want to use, whatever the situation is. So if you decide that you um, would like to have these documents in place, and we always recommend that if you are low income, you can apply at our website, dallasvolunteerattorneyprogram.org. There is a link that says Get Help. And if you click on that, you'll basically fill out a form that asks basic information, and then you'll be part of our virtual legal clinic, which is held every Thursday. And excuse me, if you fill out that form, you'll be placed in the next clinic, and you'll get a call from a volunteer attorney on the day of clinic that will basically talk to you about what you want in your wills, your power of attorney, and that sort of thing. And then if you are qualified, then our office will find a volunteer attorney to actually draft the documents for you, and then help get them signed and that sort of thing. If you're not low income, you may ask, do I need an attorney to draft all this stuff for me? It's always wise to use an attorney because attorneys are very familiar of what language needs to be in these documents, that sort of thing. Um, what about the will kits that we see online? I always recommend staying away from those because a lot of the stuff you find online is not Texas specific. And our probate judges are very particular. They want certain language in our wills, and if it's not there, it can kind of cause confusion. So I am not a fan of those online estate planning forms. Um, One website that I will tell you about is called texaslawhelp.org. They do have a sample will and power of attorney that is very good for free that you can download, fill out, get signed and notarized. I will warn you, it's texaslawhelp.org, not .com. There's a .com version and it's a paid site. If you're going to texaslawhelp.org, they ask you to pay for something, you're at the wrong site. Um, TexasLawHelp.org also has a lot of other great legal information for other topics as well, so kind of just keep that in your toolbox. But I'm going to leave this up for a little longer so folks can get that website. And I am going to try to get in the chat to see if we have any questions.
Tell you, well, Kristen, I have questions if they don't have
Okay.
questions. Um, so if so the will kind of supersedes all these other documents, or do I need the will and all these documents?
So you need the will and the powers of attorney.
Oh,
So the
okay,
powers of attorney are going to be in effect while you're alive, but
okay.
once you die, then say, for example, if you have a statutory durable power of attorney that lets somebody you trust access your bank account, that's going to be around while you're alive. But the minute you pass away, that statutory power of attorney is no longer good, and you have to follow whatever's in your will.
The will. Okay.
Yeah.
So just because I'm married and it's just me and my husband doesn't automatically mean he gets to or she gets to decide everything, correct?
Correct. That is absolutely correct. Um, so sometimes the husband will get everything, but not always. So it's
Okay.
always better to have that will in place.
Okay. Well, I tell you what, you certainly educated me on all this stuff, and it's certainly good for our homeowners, our potential homeowners, to know this information. So, if they wanted to contact, they couldn't contact you directly because you're at Dallas Volunteers. Is that correct?
They cannot contact me directly, but they can
Go to your
apply with
website.
us at the website and basically get help.
Right.
Exactly.
So they go to that's dallasvolunteerattorneyprogram.org or
.org.
scan the
Yes.
QR code. Yes.
Yes.
Okay.
Exactly.
Maritza, do we have any questions? Does anybody have any questions while we have this subject matter expert on the line?
No, I don't see any in the Q&A or in the chat. Oh, wait, one just came in. What is the difference income requirements for the program?
Okay, so for our program, we folks have to be low income. We are looking at 200% of the federal poverty guidelines or less. Um, if you're a vet, we do have some funding that we can go a little higher, and that's going to be different for everybody depending on how many folks are in the household. Um, so yeah, I can't give you a flat number. So if you do apply online for us, one of the first questions you're going to be asked is about your income. And then our office will actually be able to tell you, whether or not you're eligible or not.
All right. Do we have any questions out there? While we have this subject matter expert online, we certainly want to thank everybody for joining us. Oh, there she goes. Kristen Salas. She's a mentor
Yep.
attorney with Dallas Volunteer Attorney Program. Make sure you guys make note of these websites and this valuable, valuable information. Well, Christian, we're going to have you again.
Okay. I always love to talk about wills.
Oh, well, we certainly do thank you for your time and your effort, and we
Sure.
appreciate this valuable information.
Of course. Well, congratulations, everybody, on the new homes.
Yes, indeed. Well, thank you very much for your help, and thank you for everything. And even the COO, Corey, says, great job. This was very informative. Thank you so
Great.
much.
All right.
All
Thanks,
right.
everyone.
Thank
Thanks, everyone.
you. Good
Goodbye.
night.
Good night.